Article 1197. If the obligation does not fix a period but from its nature and circumstances, it can be inferred that the period was intended. The courts may fix the duration thereof. The courts shall also fix the duration of the period when it depends upon the will of the debtor. In every case, the court shall determine such period as may under the circumstances have been probably contemplated by the parties. Once fixed by the courts, the period cannot change by them. So, this provision answered the question, when can the court fix the period? Article 1197 provides for two grounds. The first one is the period was intended. The second one, the period depends upon the sole will of the debtor. So, when can the court cannot fix the period? The first one is no term was intended. Number 2 is payable on demand, and the last one when period is specified by law. That's it. So now, let's continue to Article 1198, the last article of the obligations with a period. Article 1198, the debtor shall lose every right to make use of the period. The first one is when after the obligation has been contracted, he becomes insolvent unless he gives a guarantee or security for the debt. Number 2, when he does not furnish to the creditor the guarantees or securities which he has promised. Number 3, when by his own acts he has impaired said guarantees or securities after their establishment, and when through a fortuitous event they disappear, unless he immediately gives new ones equally satisfactory. Number 4, when the debtor violates any undertaking in consideration of which the creditor agreed to the period. Number 5, when the debtor attempts to abscond. So, let me discuss to you the situations when will the debtor lose his right to make use of the period. Number 1, when after the obligation has been contracted, he becomes insolvent unless he gives a guarantee or security for the debt. If the debtor has lots of obligations, then he wouldn't be able to fulfill his obligation through payment. That is when he becomes insolvent. For example, Mr. Loan owes 10,000 pesos to Mr. Creed demandable on October 16, 2021. Before the period comes, Mr. Loan becomes insolvent. That is when Mr. Creed can demand an immediate payment from Mr. Loan, unless Mr. Loan gives a guarantee or security for debts such as house as collateral. Number 2, when he does not furnish to the creditor the guarantees or security which he has promised. For example, Mr. Loan promised to mortgage his house to secure the debt but fails to furnish the said security as promised. He'll lose the right to make use of period. Number 3, when by his own acts he has impaired said guarantees or securities after their establishment, and when through a fortuitous event they disappear, unless he immediately gives new one equally satisfactory. If the debt is secured by a mortgage in the house of Mr. Loan, but the house was burned either intentionally or unintentionally, he'll lose the right to make use of period unless he gives another security or another collateral. Number 4, when the debtor violates any undertaking in consideration of which the creditor agreed to the period. If he undertakes to render some service but fails to do it, the creditor has the right to demand immediate payment. Number 5, when the debtor attempts to abscond. If Mr. Loan changes address without informing the other party, which is Mr. Creed, as a creditor, then this means that he has intention of escaping from his obligation. This act shows the sign of bad faith. Whatever in 5 cases as mentioned in Article 1198, the debtor shall lose every right to make use of the period. It means the period is disregarded and the obligation becomes demandable at once or demandable immediately. So, this is actually based on fact that debtor might not be able to comply his obligations. So that's all for today. Thank you for listening. I hope you've learned something in my discussion. Mabuhay and